Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-34, United States of America versus William Galloway, appellant. Ms. Mehta for the appellant, Mr. Hobel for the appellate.
Ms. Mehta, good morning.
Good morning, Erica Hashimoto from the Georgetown Law Center's Appellate Litigation Clinic. With the court's permission, Sophie Mehta, a third-year law student at Georgetown, will present argument for Ms.
Okay, thank you. Ms. Mehta, good morning.
Good morning. Good morning, and may it please the court. The district court committed 2 errors at trial, and I will address the issues in reverse order of how they appeared in the briefs. First, the district court abused its discretion in admitting evidence of Mr. Calloway's prior conviction under Rule 404B. Second, it also erred in restricting defense counsel from cross-examining a key government witness about the very issues the government raised on direct examination. These 2 errors were harmful, and this court should reverse and remand for a new trial. First, although the government contends that the evidence in this case can support both actual and constructive possession, the evidence that it introduced belies this notion, as it can only support actual possession. And the government's response has no answer to the question of when Mr. Calloway could have been in constructive possession of the firearm at a time when he was not allegedly in actual possession of it. As the Supreme Court has noted, constructive possession is established when a person lacks physical custody over an object, but still has the dominion and intent to exercise control. Mr. Calloway was not in a position to exercise dominion and control over the firearm, and this court has been clear that that is a determinative question in a constructive possession analysis. The firearm here was recovered in a public park across a creek. It was removed from a situation where the firearm was found underneath a defendant's seat in a car or next to a defendant's feet. To hold that there is constructive possession here would broaden the scope of this court's precedent.
I'm not saying I think this is the right test, but I wonder what you think of this. Actual possession, that's when a weapon's recovered from a defendant's person. Constructive possession, the weapon's recovered from an area where the defendant was in or known to be in.
Yes, Your Honor, I would agree with that. The actual possession comes from when a defendant has direct physical possession over an object. But
So if that were and again, I'm not endorsing the test, but if that were the test, here we have a weapon that was recovered from the area that the defendant was known to be in. It wasn't recovered right off of the defendant's person, body. So that if this would be the test, then it sounds like this test would cut in the direction of constructive possession.
no, Your Honor, here, because in this case, Mr. Calloway, when he allegedly threw the firearm across a creek, at that moment in time, he no longer has dominion and control over the firearm, and therefore a constructive possession theory cannot be supported on this evidence. But even if this court were to find that the 404B evidence is admissible for a constructive possession theory, it should still be excluded on Rule 403 grounds. The government was clear that constructive possession was a fallback or alternate to its primary theory of actual possession. And the constructive possession theory had, at most, limited evidentiary support. The key reason why this evidence was so prejudicial was because it was overly broad. The government introduced that when Mr. Calloway was convicted of possessing a firearm in 2016, he had already been convicted of a crime with a penalty greater than 1 year. That prior act's evidence that he had already been convicted of the identical crime of being a felon in possession magnifies the risk of prejudice here and is irrelevant. Additionally, the final jury instructions here could not mitigate this prejudice, as they failed to specify that the prior act's evidence could only be used to demonstrate knowledge under a constructive possession theory, leaving open the possibility that the jury would use this evidence in convicting Mr. Calloway under an actual possession theory, which is foreclosed by Linares. Under either Rule 404B or Rule 403, this evidence was harmful. The sole evidence the jury knew of Mr. Calloway outside the events of October 4th, 2018, was that he'd been convicted of the identical crime of being a felon in possession. The prejudicial impact of this prior act evidence substantially outweighs its probative value, which at most was minimal.
What do you think the gap is between an evidentiary ruling that if I were a district judge, I would have made different, and an evidentiary ruling that I would have made that is air? I didn't say that very well, but so you can imagine a district judge making an evidentiary ruling that you disagree with, but that it's within the range of discretion. And you can imagine a district judge making an evidentiary ruling that's so far out of the range of discretion that it is air. Why is this on the side of the line you want it to be?
For two reasons, Your Honor. First, in light of this court's precedent in the United States versus Linares, that is under that case, if the evidence can only support actual possession, then Rule 404B evidence should be excluded. And even on 403 grounds, which does give the district court discretion, here, because the probative value of this prior act's evidence was so low, and that is why the prejudicial impact of it, given how identical it was, how recent it was, substantially outweighs the probative value. Turning to the confrontation clause.
Before you do that, can you just address harmless error? I mean, you make a fair point under Linares, but the evidence was overwhelming. You've got his fingerprints on the gun established to a certainty. You have police eyewitness testimony that he's dumping the gun in the woods. I mean, this issue you're raising is just academic.
Yes, Your Honor, the errors here would still be harmful for three reasons. First, as mentioned, the prejudicial impact of it. Second, this court assesses harmless error under a cumulative standard, and the impact of the prejudicial prior act's evidence must be viewed in addition to the fact that a key government witness was precluded from, that Mr. Calloway was precluded from cross-examining a key government witness. And though there is substantial DNA evidence here, the DNA evidence lacks a temporal aspect in the sense that it doesn't specify when Mr. Calloway possessed the firearm, and the government does bear the burden of proving that he possessed it on the night of events in question on October 4th.
So he's there at that time and place. He goes in the woods, he comes back, they find the gun in the woods, his fingerprints are on it. That's not enough.
In this case, Your Honor, in particular, because of the fact that there are two errors here under a cumulative standard.
So I'll let you come back. I understand the cumulative point. And if you win on the first argument, the one you're trying to get to, the case for harmlessness becomes more difficult. But just assume for now that we reject your cross-examination point. We're just thinking about harmlessness under Linares. I'm just not seeing why this matters.
Even still, Your Honor, if there is only one error in this case, this court must pay attention to the fact that it was highly prejudicial, it was identical, it was a recent, and in conjunction.
I mean, maybe that's just positing that there was an abuse of discretion under 403, but there's always a separate harmless error analysis which turns on the other incriminating evidence in the case.
Had there been some conclusive evidence, such as video evidence of Mr. Calloway possessing the firearm, in that case, the error here would be harmless. But the DNA evidence here does lack that temporal aspect. And in light of that, it is still the government's burden to prove that Mr. Calloway possessed the firearm on October 4th, 2018.
Okay, I understand. You can go on to your other point.
Briefly on the issue of the confrontation clause, the government never engages with the critical fact that Ms. Palmer's testimony was central to this trial because the DNA expert's testimony depended on the jury's assessment of Ms. Palmer's credibility and her motives for testifying in this case. The government stated in its pretrial motion on JA 49, if the issue of testimonial bias came up, Mr. Calloway would have a limited right to cross-examine about it. And the government did elicit testimony that Ms. Palmer was aware of the DFS's loss of accreditation and that had no effect on her testimony in this case. In response to that, Mr. Calloway's questions only sought to determine whether Ms. Palmer's knowledge of the DFS's loss of accreditation and the reasons for it had any effect on her potential motive to lie while testifying here. It's also important to note that what Ms. Palmer may have said and how this may have impacted the jury's impression of her credibility speaks to whether any error here was harmless. The error here would be the preclusion of cross-examination, and the government bears the burden of demonstrating a harmless error. I see that my time has expired, and in light of the foregoing errors, this court should reverse and remand.
All right, we'll give you a couple minutes in reply. Thank you.
Thank you.
Mr. Hobel.
May it please the court, Mark Hobel for the United States. The district court did not abuse its discretion in admitting Rule 404B evidence of prior gun possession. And it also did not abuse its discretion in limiting cross-examination of an evidence collection witness from DFS.
What's the theory of relevance that doesn't involve a propensity inference?
Knowledge and intent of the firearm through a constructive possession theory, as in Garner.
How does that work on the facts? I mean, there's, as I said, pretty good evidence that he had actual possession. I don't see how the facts might support conclusion that he had constructive but not actual possession.
There's very good evidence that he had both actual and constructive possession. The jury was instructed on both possession and constructive possession without objection.
What's the theory? What's the theory for constructive?
Theory of constructive possession. I want to rewind the tape a little bit from the gun toss. So let's start with the shots that are fired 5 minutes before Officer Jameson arrives on scene. There are 4 people, including Calloway. They are seen just minutes later, standing essentially on top of the shell casings that we know by stipulation were fired by this gun just a few minutes before. So you have, and the gun is found also in proximity to Calloway in the wooded area. So you have a group of people. You have somebody firing shots. There's no direct evidence that it's Calloway firing the shots. And in this case, we'd submit this is like Garner, in which the court recognized that the government had a heightened requirement to prove dominion and control, where there are multiple people on scene with access, and there's a potential defense of one of these other people had exclusive possession of the gun. I know that was in fact the defense that Calloway put on by calling his friend Kevin Bryant, who was also there, to say, that was my gun. Calloway never knew about it. So knowledge and intent of this gun was squarely at issue. And then even if you again sort of fast forward.
Haven't you left out that Calloway ran to the creek?
That's right. And that's where I'm going next. The next stage of this is when Officer Jameson shows up. He sees Calloway, the only one of the group, moving into the wooded area near where the gun is later found. And again, Garner, this court noted that Garner's movements towards the object in question, the gun in question, that supported a constructive possession theory.
So the jury a reasonable jury on these facts could find that one of the friends stashed the gun in the woods, and then Calloway sort of knows this and is later going to get the gun?
I think a reasonable jury could, I'm not sure it needs to go as far as find. A reasonable jury just needs to entertain a reasonable doubt that it was Calloway that fired the gun. But it could find beyond a reasonable doubt that Calloway, standing with that group, his DNA all over I believe it was DNA, not fingerprints. It was DNA all over the gun and magazine. Right.
Yeah. Sorry.
That Calloway knowingly exercised dominion and control at a time that he was not actually in possession of the gun. And again, it's just, the jury's just got to, entertain a reasonable doubt as to who actually fired the gun. As to the movements into the woods, that is evidence suggesting his connection, Calloway's connection to that gun, his knowledge of the gun, even if the jury, of course, could reasonably infer he tossed the gun. But, that is not the inference it had to draw in order to convict. In other words, this isn't like Linares, in which the jury was forced into a disjunctive choice between actual possession or no possession at all. Constructive possession was very much on the table. The jury was instructed on it, and without objection from Calloway. And the defense that Calloway put on was that one of the people there with Calloway, Kevin Bryant, had exclusive possession of the gun, and that Calloway didn't know it. And one thing I want to respond to from Calloway's reply brief as to Kevin Bryant, just the sequencing and when that information comes up. The relevant, I guess, error that they're alleging is the admission of the evidence. The evidence, 440 evidence is admitted at the end of the government's case. That morning is when the defense counsel shows up in the middle of the government's case and says, Your Honor, I have a defense witness who is going to claim that he had possession of the gun. It was his gun. So, at the moment that the evidence is admitted, and I think Garner says specifically, we look at this from at the time the evidence was admitted. I know in Cassell too, there was a similar issue where the district court revisited its pretrial ruling in light of the way the defense put on its case. So at the time the evidence is admitted, the district court is aware that the defense is going to call a witness who's going to claim exclusive possession of the gun. So knowledge and intent are just, at the foreground that the evidence comes in. So Rule 404B is a rule of admission.
I have a couple of confrontation clause questions. I don't want to cut you off if you got one last huge point you need to make.
No. I was just going to point out that on 403 that we it was substantially probative. This court has noted this type of evidence is substantially probative. It's little prejudice given the limiting instruction. With respect to the confrontation clause issue,
let me ask mine.
Yeah, I'm sorry. I'm
okay.
Very sorry.
No, is it conceivable that there could be a limit on cross-examination that does not violate the rules of evidence, but does violate the
in the context of the testimonial, non-testimonial, witness absent, that area of the confrontation clause, maybe yes. In the terms of how cross-examination is in this other area of the confrontation clause, limiting cross-examination, I have a hard time seeing how the district court could not abuse its discretion under Rule 403, but still violate the.
Then I have a standard of review. Sorry.
Okay.
Standard of review question. Sometimes confrontation clause issues are reviewed de novo. Sometimes they're reviewed for abuse of discretion. I think you both agree it's abuse of discretion here. I think I agree it's abuse of discretion. But what is the line there between when we review a confrontation clause question for de novo and versus abuse of discretion?
I think abuse of discretion encompasses legal error. So if the defense were alleging a legal error, I think it would be de novo. But here the defense is just essentially, I think, is somewhat conflating the 403 and the confrontation clause issues and saying the limits placed on cross-examination were just too stringent. And I think that's a classic, issue, a classic 403 issue and subject to abuse of discretion. And the district court has very, very broad discretion in this area. And I just know with respect to the DFS issue, I think where the parties are actually in agreement is we're in agreement on a lot of facts here, which is that The misconduct at DFS had nothing to do personally with Katrina Palmer, this witness, that she engaged in routine evidence collection, and that swabbing the gun for a dead magazine for DNA, and that's it, and that she performed that work in 2018 before the investigations that led to the accreditation loss had even arisen. And of course, the report that she authored came into evidence, documenting her work from that. So, from the district court did not abuse its discretion, allowing some limited cross on this issue, but in cutting it off before things went down a rabbit hole with DFS, is the defense counsel, I think. So unless there are any further questions, we would ask this court to affirm the conviction.
All right, thank you.
Thank you.
Ms. Mehta, why don't you take 2 minutes?
Thank you, Your Honors. In regard to the 404B issue, the government still has not pointed to a time Mr. Calloway could have been in constructive possession of the firearm at a time when he was not allegedly in actual possession of it. Mr. Calloway did object to this issue at the motions hearing, which is sufficient to preserve this issue. Second, this court has been clear that the threshold level of cross-examination that must be allowed is cross-examination into a witness's motives and bias. Here, the government did raise the issue of DFS's loss of accreditation on direct with Ms. Palmer. And perhaps if this issue had not come up, the abuse of discretion question would be closer, but the government opened the door to this issue. Third, the government does bear the burden of demonstrating harmless error in this case, and specifically, it must demonstrate that the error at hand did not have an effect on the verdict, not whether the evidence absent the error would have been sufficient. Finally, this court does consider harmless error under a cumulative standard. Viewed in the aggregate, restriction of cross-examination in the admission of Rule 404B evidence was harmful. Mr. Calloway had a right to inquire into Ms. Palmer's motives and bias, and the jury should not have learned his prior conviction. We would ask this court reverse and remand. Thank you.
All right, thank you, Ms. Mehta. And you were appointed by the court to represent Mr. Calloway, and we thank you for your very able assistance. We thank the entire team.
Thank
We got one.
Case number 22-1226.
Okay.
Riverdale Mills Corporation.
I thought I was missing.
Petitioner versus Secretary of Labor. Mr. Vance for the petitioner, Ms. Pontilio for the respondent.
All right, Mr. Vance, good morning.
Good morning, Your Honors. It please the court. Travis Vance with Fisher and Phillips. My colleague Sharon Saul and I represent Riverdale Mills Corporation. President for Riverdale is their internal counsel, Cyril Means, and President Jim Knott. There are 3 OSHA citations at issue here, and with respect to each of those citations, the administrative law judge made findings of fact based on assumptions and evidence that was either not admitted at trial or should have not been admitted. The question today for this court is, will it permit an administrative law judge, and then as upheld by the OSHRAC Commission, to make inferences, assumptions, and conclusions without factual basis to uphold 3 citations where OSHA failed to marshal the evidence at trial required to prove it? As this court may know, there's 2 cases at issue here. There's one related to safety issues and another related to health issues. One of the first citation I'm going to address is in the safety issue. That is respect to the spindles at Riverdale's facility. In the citation, OSHA issued a citation for failure to do certain annual certifications concerning a big spindle at the facility, but at trial, the only evidence that was demonstrated or marshaled related to the C spindle. There was absolutely no evidence that the big spindle, as cited, was the same as the C spindle. In fact, OSHA's own inspector noted there were 3 spindles on the line at Riverdale, and it could have been either of those 3, any of those 3 spindles, but there was absolutely no evidence that the cited big spindle was in fact the same as the C spindle.
Now, let me ask
Yes,
about that, please. It seems like the record is talking about one specific spindle, and the citation refers to one specific spindle.
yes, sure.
It just seems almost absurd that the citation would have referred to a specific spindle that is different than the one specific spindle that the entire record is talking about.
Yes, Your Honor, I tend to agree with you. But with respect to the burden of proof, OSHA would have that at trial. And here, the evidence was clear that there were 3 different spindles on this particular line. And there was never any evidence to demonstrate that the C spindle, which was the spindle that was noted on the lockout tagout sheet that did come into evidence, there was no evidence to demonstrate that was the same as the big spindle that was cited.
What if the citation had just said the spindle?
Well, I think that would be a different case. But I think in that case, OSHA would have the burden to show that the spindle cited in the citation is the same one where there was an exposure actually at the workplace.
So don't you think we could infer that a citation that says the spindle is referring to the only spindle that was discussed in the record?
Where there were other spindles discussed, Your Honor, if you look at even the compliance officer's testimony, they talk about 3 different spindles and actually each of the spindles having a different lockout tagout procedure. And the Secretary on Appeal has made the new argument that, well, they work in that area, so there had to be some sort of exposure. But our position here is, and our request of this court is to make OSHA meet its burden by demonstrating at trial in front of a finder of fact that, in fact, what the company was cited for is what existed in the workplace. And here, OSHA would have to demonstrate there was an actual exposure to employees because of a failure to not do an annual certification for lockout tagout on the big spindle. But at trial, there was never any evidence to demonstrate that that actual spindle caused any exposure.
And I overstated it a little bit when I said there was nothing in the record about the other spindles. But is it true that there was nothing in the record about any kind of mistakes that were made with regard to the, let's call them small spindles?
Yeah, there was no, if I think this is what you're asking, Your Honor, there was no demonstration that there was an error with the other spindles as far as meeting the standard. That is correct. The citation focused on the big spindle, but at trial, there was an issue with the C spindle because that was the only spindle OSHA could demonstrate that had been serviced within a year prior to the inspection. So therefore, there might have been a hazard. But the issue with OSHA's case is they didn't cite for that spindle. They cited for the big spindle and never crossed the bridge to show the big spindle was the same as the C spindle. And our issue with the ALJ's decision is she bridged that gap for OSHA without any evidence being presented that would allow her to do so. And the same issue applies, Your Honors, for the safety data sheets concern. That issue is whether or not the employer provided the safety data sheets or provided access to OSHA of the safety data sheets within 15 working days, or would have noted why they couldn't provide it within a certain amount of time. But the issue here, and what the same bridge that the ALJ filled for OSHA without evidence, was that OSHA, there's no evidence in the record that shows that OSHA specifically asked for, chemical A, chemical B, chemical C of a safety data sheet, and she filled in the gaps. The administrative law judge filled in the gaps as to what OSHA actually requested. So our position is the same there for the safety data sheets as it is with the spindle, is that we're asking this court to not allow the ALJ to uphold citations against a family-owned business where the government has failed to meet the requirements of that citation without any evidence in the record. And so with respect to the safety data sheets, the secretary has not addressed the fact that at the opening conference in that inspection, there was no specificity as to which chemicals the safety data sheets were requested for. And more importantly, the follow-up email that was sent from the OSHA inspector to Riverdale was unfortunately sent to the email address of a deceased former president of the company. And of course, there was no response to that. That email had some specificity to it, but the actual request from OSHA to the company never addressed, give us this safety data sheet, give us this safety data sheet, give us this safety data sheet. And more importantly, the testimony at trial was that Ms. Hart, the inspector, noted that she was provided the safety data sheets for chemicals 4, 5, and 6 on the safety, the chemical key that was in the record. But at trial, OSHA tried to say that it was other safety data sheets that were not provided, but those were never specifically requested. And again, our position as the administrative law judge is trying to bridge that gap for the government without any facts in the record. With respect to the final citation, Your Honors, that relates to the hazard communication training to one single employee. The only evidence in the record on that particular citation is a out-of-court hearsay statement from a non-manager of the company. It was permitted in without the company being permitted to cross-examine that witness. He did not appear. He could not be located by the government. It was hearsay. We think that it should have been excluded under Rule 403. And even if not excluded on its face, we think that it meets his testimony in that statement, specifically notes that he was given the training that's required by the standard. And Your Honor, I see that my time is up, and I will reserve my remainder of my time.
Thank
you very much.
Ms. Bonfilio.
Good morning, Your Honors. May it please the court. My name is Anne Bonfilio, and I represent the Secretary of Labor. The issues in this case are primarily factual and therefore governed by the substantial evidence standard, which requires something less than a preponderance. Here, the commission decision is adequate to support the commission decision must be upheld if a reasonable mind would find that the evidence in the record is adequate to support the ALJ's findings, and the record is adequate to support the findings for the 3 issues in this case, and I'll take them in the same order that Mr. Vance did. So starting with the lockout tagout standard, OSHA's lockout tagout standard protects against the unexpected energization of machines, and it requires that employers establish and use procedures to put locks and tags on machines to stop that energization and to conduct annual periodic inspections of the employees who would be performing those procedures. And that's the issue here. The purpose of the periodic inspection requirement is to ensure that workers are competent in lockout tagout and that they're protected from the hazard of performing lockout tagout without knowing the correct procedures to work on that machine. And Riverdale does not dispute the ALJ's findings that they violated this requirement. They just dispute the exposure element. And here, the record shows that Borden was actually exposed to performing lockout tagout without having received a periodic inspection via the lockout tagout log from April 2019, which shows that he performed lockout tagout on the C spindle. And Riverdale doesn't dispute the authenticity of the log or Borden's testimony about performing lockout tagout on that date. They argue that the C spindle was not the big spindle and that there's no evidence in the record to support that, but that's not correct. So Borden testified that the lockout tagout procedure that's listed in the citation, RMC 022 for the big spindle, was the procedure that advised of the hazards associated with the C spindle, and that was the procedure he referenced when performing lockout tagout on the C spindle. Additionally, the secretary requested all lockout tagout procedures for Riverdale's operations and received just one lockout tagout procedure for the spindle. So that lockout tagout procedure, RMC 022 in the citation, was the only procedure that Borden could have referenced when performing lockout tagout on the C spindle. Finally, if you look at the video and the photographs of the facility, you'll see that you have one big spindle that is the terminal point on the coating line, and you have two smaller spindles that are set aside. It's unreasonable to suggest that those spindles, aside from the coating line, are the C spindle. And considered together, this documentary evidence shows that the record was adequate to support Borden's testimony and the ALJ's finding that there had been exposure to the lack of a periodic inspection.
Why would it be unreasonable to think that one of the smaller spindles was the C spindle?
Because the smaller spindles, if you look at the photo, the coating line, if you're able to view the video, you'll see that the mesh travels through a series of machines, and the last machine that receives the mesh is this big spindle, spindle number 1, or the main spindle. It had a number of different names that were referred to during the trial. And the small spindles were not in use. They were off to the side. So to say that the coating line was a spindle not attached to the coating line just doesn't seem reasonable, and especially considered with Borden's testimony that there was one procedure and that was the procedure referenced. I'll also just note that Mr. Vance has mischaracterized the COSHA's evidence or testimony here. What the COSHA said was that there are 3 spindles, but there was only a unique procedure offered for the spindle machine. The other procedures referenced refer to other machines on the coating line, but not the other spindles.
Refer to other what?
Other machines on the coating line. So like a primer machine or a wash machine, but not a different spindle.
He said a minute ago that each of the 3 spindles has its own lockout, tagout procedure. Is that right or not?
That's not reflected in the record. So when the secretary requested all lockout tagout procedures, only one was produced for a spindle, which was the big spindle. And when the COSHA, the compliance officer, was asked about this, he said there was a unique procedure for the spindle. So it's important. So considering his testimony as provided, there was just one procedure for the spindles. Moving to the issue of the safety data sheets for the HAZCON standard, the ALJ properly found that Riverdale did not provide the safety data sheets in a timely fashion as required under the standard. Notably, at the closing conference, Riverdale still failed to produce safety data sheets for chemicals 2 and 3, chemicals on the coating and galvanizing line. The OSHA is not required under the standard to specify chemical by chemical what they are seeking. They may request all safety data sheets, and here the record shows that the request has always been for all safety data sheets on the coating and galvanizing line. And you can see that in Exhibit 49, which is Area Director Hoy's email prior to Investigator Hart's inspection, where she references all chemicals in Riverdale's coating and galvanizing line operations.
Can I ask you a question about the governing legal standard? We have any number of cases saying that citations are reviewed under this 4-factor test, which includes employee access and employer knowledge. And everyone seems to take that as a given. I understand how you get that test for serious violations. Don't understand how you get that test for non-serious violations. And this is a non-serious violation, right? The statute says you have to follow a safety standard. The safety standards don't talk about employer access or employee access or employer knowledge. And there's just kind of a square peg round hole problem. What does it mean to say employee access where you're talking about failure to provide a record in a timely fashion? So why do we consider those elements at all for this non-serious violation?
So for the non-serious violations, Your Honor, the access element, I believe, and this is referenced in a footnote in the Secretary's brief, is actually dropped. So it is only a 3-part test for the record-keeping violations or the non-serious record-keeping violations, which this is. So
It drops employee access.
I
Okay.
believe so. So we're looking here at the violation, and we're looking at knowledge, and we're looking at
How does knowledge come in?
so here, Riverdale knew that they did not provide the safety data sheets that were requested.
No, I know, but why is it relevant?
It's so in the OSHA cases, you're looking at knowledge of the violative conditions. So here we would just be saying the employer knew of the request and they did not provide a response to that request. And they were aware of that. There wasn't some inadvertence that led to them.
No, I understand.
Yeah.
I understand your position that any knowledge requirement is met. I'm not sure you would have to meet it, but
It's possible. For this case, we're really focusing on the violation.
Right.
So here, right, the violation was established by them failing to provide the safety data sheets for chemicals 2 and 3. And I'll just note that even if the ALJ had erred in not crediting Riverdale's claim that they believed the scope of this request was only for air contaminants, chemical 5, which is listed on the citation, is an air contaminant under OSHA's air contaminant standard and should have been provided if that was what they did indeed understand. Quickly addressing the hearsay point, Your Honor, it's well established under commission case law that statements to compliance officers are non-hearsay under 801D2D. The reason for that is because employers know what their employees are saying and can offer rebuttal evidence, as Riverdale did do in this case. We had an 8-day trial and Attorney Means was present when the statement was made. They had an ample opportunity to respond. I see my time is up.
All right. Thank you.
Thank you.
Mr. Vance, I think you have some time remaining.
Your Honor, just real briefly, with respect to your question, Your Honor, with respect to employer knowledge, at trial, Ms. Hart, the inspector, was asked, and with respect to missing safety data sheets, you do not know that any manager or supervisor at Riverdale Mills was aware that any safety data sheets had not been produced at OSHA, correct? For response, I do not know what they were aware of. With respect to the position offered by counsel on the June 17th, 2019 email, exhibit R49, talking about all safety data sheets with powder coating and galvanizing operations, we believe that was a misinterpretation of that. It actually is an email to Riverdale's prior counsel from the area director for OSHA that says, I appreciate that Attorney Anastasopoulos provided all the safety data sheets associated with the powder coating and galvanizing operations at Riverdale Mills. We will be in touch. So there was a reference to the powder coating and galvanizing operations, but only in the context that OSHA is acknowledging that all the safety data sheets had been provided. And at that point, going forward, there was only a generic request for safety data sheets. When OSHA shows up looking for air contaminants, the request was all safety data sheets not previously provided. And there was never a request from OSHA for specific chemicals. Finally, with respect to the spindles question, Your Honor, the testimony from Compliance Officer Grabowski, he testified that he did not know, quote, if the same procedure for the big spindle lockout can be used to lock out a different machine, because there were multiple energy control procedures that were provided. So our position is the testimony, Your Honor, was that there was no evidence that the C spindle, a lockout tagout procedure would work for the big spindle or vice versa. We respectfully request that this court reverse the administrative law judge as upheld by the OSHA Commission's decision. Thank you very much.
Thank you.